Okay, great. And I did want to play Fitty, as he is famously known, because this song In the Club is from 2003. So this is the kind of music, a lot of students were listening to when the whole Facemash incident exploded on the Harvard campus. And it really turned out to be a big deal. In fact, I'm going to play a film clip, not of Jesse Eisenberg, playing Mark Zuckerberg. Hopefully, you've been able to see the movie. And I have included some film clips from the movie in our module number 2, the social network, the Facemash scene. But what I want to play you the real life Mark Zuckerberg. He was actually asked about Facemash before the Congress. Representative Billy Long of the great state of Missouri decided that, you know what, let's get to the bottom of Facemash. So let me play that for you. Great, I have it pulled up. So I'm going to go ahead and screen share right now. By the way, this gives you a chance of seeing the law in action, the lawmaking process. The law is not just courts, judges, and juries. Also, there's lawmakers in the form of legislators, and also executive officials like the governor or the president on down, and members of the cabinet. So here we have an esteemed member of Congress, the Honorable Representative Long, who, by the way, my understanding comes from a very illustrious family, political family. His dad is Russell Long, used to be the chairman of the Senate Finance Committee, perhaps the most powerful man in Washington next to the president, as the Finance Committee has to approve any appropriation, tax, and spending bill. Also, great-grandfather of Huey Long, the populist governor of Louisiana, who had ambition to become president back in his day. So here's this, this is a political legend that we're about to see here. And watch Mr. Zuckerberg respond.
Facemash, and is it still up and running?
No, Congressman. Facemash was a prank website that I launched in college in my dorm room before I started Facebook. There was a movie about this, or it said it was about this. It was of unclear truth. And the claim that Facemash was somehow connected to the development of Facebook, it isn't. It wasn't.
Just coincidental. The timing was the same, right? Just coincidental.
It was in 2003.
Okay.
And I took it down, and it actually has nothing to do with it.
You put up pictures of 2 women and decide which one was the better, more attractive of the 2. Is that right?
Congressman, that is the prank website that I made when I was a sophomore.
Okay.
All right, I hope you enjoyed that. And you see that Mark Zuckerberg, right, trying to kind of play down, the significance of Facemash. But I've also included in your module 2 what I think is essential reading. If you're going to read one thing in this module, please read the Harvard Crimson. Please read Barry M. Schwartz's excellent article, Hot or Not, website briefly judges students on looks. This is just a tour de force of student journalism. And, and I will tell you, the Harvard Crimson has itself a stellar list of alumni, going all the way back to President Franklin D. Roosevelt, class of 04. He was the president of the Crimson back in his day, 100 years, before the Facemash incident. John F. Kennedy at one point, was the business director of the Harvard Crimson. Brandon Williams, a lot of famous journalists, both conservative, liberal, etc., have worked at the Crimson when they were students at Harvard. And Barry Schwartz's article is really excellent. And the Crimson was very gracious enough to give us permission to repost their article. And let me just say that what's really amazing about the article is that it's describing the world that we live in today. It's a really remarkable, today we just take it for granted, cancel culture and, something going viral on the internet. I mean, that's just a given, that's surprising if it doesn't happen on a daily basis, multiple times a day. But, Mark Zuckerberg, he's about to get canceled, because something that he posted went viral. And, what's super remarkable about the Facemash is that back in 2003, of course, there's no Facebook, there's no Twitter, there's no YouTube. All of those platforms are going to be launched in the near future. There's no iPhone. That's not going to be launched until 2007. Only a very select few had a Palm Pilot device or a BlackBerry device, that maybe had the capacity of sharing a link and that kind of stuff. So this is people students on their computer, 400, in a few hours that the website was up and running, no less than 450 students, got on the site and voted, 22,000 times, on the hotness of various students. And what's also remarkable is that what's really neat about this article is that it's the ABHW, Association of Black Harvard Women, and Leila Bravo, the Fuerza Latina president. They are the ones who come out, and kind of instigate this story, because the outrage they feel that they are being, and their classmates are being ranked in a kind of subtle, invidious way. This is really unfair, not just to women, but also to, women of color. It's just a remarkable story. So what I want to do is, let's do this. Let's look at our survey results. I'd like to see what the class thinks about the whole Facemash stuff. And then I'm going to build the lecture based on those survey results. So what I'll do is, for that purpose, is I just need to get out of this YouTube screen and pull up the survey results really quick. And then I'll do a screen share. So just bear with me. I'm going to click on survey results. I'll take a little while to load. Then let me get back into screen share modality here, and just want to show you for your show everyone. I think that's it. Let's see if that works. All right, great. We are in the quiz now, and this will be cumulative. If there's any, I'll note if there's any significant deviation here from the results, or if these results are consistent from our previous sections. But the first question I'm asking here is, and we'll look at this because I want to talk about sources of law. But the law is really a meaningless, piece of paper if it's not enforced. And so if we look at Facemash, who could bring, in fact, by the way, give me a second here to maybe, I guess I'm not allowed to. I'd like to maximize the size of this so you can see it a little easier. Who would have the strongest case against Mark Zuckerberg? And here are a number of possibilities. If you're going to bring a federal, or, you could have a federal or a state criminal prosecution. So on the federal side, every state is comprised of at least one federal district, and the president appoints and the Senate confirms a United States attorney for that district. And that United States attorney is then will have a number of career assistant U.S. attorneys, and they will enforce federal criminal law in the district. So the Commonwealth of Massachusetts at the time, Carmen Ortiz was the U.S. attorney, the federal prosecutor for the district. So we'll take a look at federal law. The other possibility here is Marion T. Ryan. She's the local state attorney or district attorney. So like Florida, Massachusetts, it's comprised of a number of counties, right? And each county or each local unit will have its own district attorney's office, all under the state attorney general's office. Harvard, I put Harvard's president there because, as the Harvard Crimson article makes very clear, Harvard has its own rules about computer use. And Zuckerberg, as the movie so memorably depicts, he's going to be ag-boarded, or brought before the student conduct committee as the ad board is known at Harvard. And so I put President Summers there as, if you will, the head of Harvard right at the time. And then I also have a classmate, Layla Bravo, who was the one who one of the students who alerted the Harvard Crimson, was interviewed at the Harvard Crimson. Maybe a possible private cause of action, as an actual victim. And here, what's really interesting is here, compared to my sections, a lot are going with federal, Carmen Ortiz. And actually, I'm gonna in this lecture, we'll take a look at that. But notice there's a little bit of support for all of the above here. So we'll take a look at each one of these in today's lecture. Also, I would like to, I'm curious, if you were on the ad board, maybe as a student member, how would you have voted? And so I have a link to the possible outcomes, and I put these possible outcomes in here. These results are fairly consistent with the previous sections. Most students would impose a penalty of probation. Now at Harvard, what probation entails, if you look at their possible outcomes on the ad board website, is that if you're put on probation, then if you're ad boarded a second time, is an automatic requirement to withdraw. So it's a probation there, that's really the big difference between being put on probation and just being admonished, So notice 10% would actually, require Zuckerberg to leave Harvard. And some 16%, is not, that's a considerable fraction, would actually also would actually dismiss him outright. Technically, the ad board doesn't have that power. They can only recommend dismissal, and then the dean of the residential house in which the student resides makes the final decision. But really, the dean is going to most likely, follow the ad board's recommendation if that were to be the case. Lastly, we have, I'd like to know what the class itself thinks about Facemash. Do you agree more or less with Zuckerberg that it's basically a prank, or is it worse than that? And what's interesting here is if you combine the last two choices, a criminal act versus just a civil wrong, the main difference there is with a criminal act, you could potentially go to jail or pay a fine, whereas with a civil wrongful act, you probably will have to pay money damages directly to your victim. If you combine those two totals, it pretty much is a tie with those that say that this is not illegal necessarily, but it is immoral or unethical. And then the harmless prank, a lot would agree with Zuckerberg that, this is being kind of over, blown out of proportion. Now, what I will say here is that however you want to classify the problem of Facemash, Facemash, in addition to being a very, beautiful cinematic, sequence in the movie, especially when the Andrew Garfield, the Eduardo Saverin character, is writing the ELO chess ranking algorithm on the board, or I'm sorry, on the dorm window. There's also a similar scene, right, in A Beautiful Mind with Russell Crowe playing John Nash, equations on the dorm window. It is, and also putting aside the fact that, regardless of Mark Zuckerberg's protestations of the accuracy of the movie, right, Jesse Eisenberg's voiceover, and you can read the blog posts for yourself in the Harvard Crimson article, right? Zuckerberg's, Eisenberg's voiceover is really word for word from Zuckerberg's blog posts. So putting all that stuff to one side, hacking continues to be a real significant, problem, and a real significant threat to economic activity and to the security of our data, and really no one is immune from the threat, and so if you will, that's another reason that's the Facemash is worth studying, because it's kind of a bellwether, it's Harvard is now being hacked, and it's being hacked from the inside. All right, so what I've done now is I prepared a lecture. Now I want to talk about hacking in order to introduce the main sources of law. So what I'm going to do is I prepare sort of a visual introduction here to the main sources of law. So if you'll allow me, I'll pull that up, and then I'll do one last screen share. And this will be a short lecture because sources of law, it's fairly straightforward, but I want to try to go into some level of profundity here. All right, here we go. And so, and here I just want to give you sort of the big picture of our legal system. So let's do one more thing here and just maybe expand the slideshow. And this is hacking and sources of law. So I always begin, or like to now begin, the sources of law by by telling you who the gentleman is on this corner. He is F.W. Maitland, and F.W. Maitland, it was a British legal historian in the 1800s, late 1800s. Actually, his work is still read today in law schools. For example, one of my favorite classes when I was at Yale was the history of the common law with Professor John Langbein, and we read a lot of Maitland's work. And let me just say, though, the reason why I show him today is because of his definition of the law. He famously described the law as a seamless web. And to this day, I and generations of legal scholars and lawyers and judges have been mesmerized by this evocative and beautiful definition of the law as a, sort of like a large interconnected system, a seamless web. And the way I like to look at it, and what we'll be talking about today, is at the center is we're going to situate local and state law as we're focusing on the US legal environment, Florida, for example. Then what I like to call the expanding web is federal law. Every day Congress is enacting, even today, I think they're considering new legislation on voting rights and, infrastructure bills. So Congress is always passing new bills and new pieces of law all the time. And then on the outer edges of the spider web, of the seamless web, I like to include their international law, which, although we don't think of international law, we think of that maybe as war criminals and, the Yugoslavia, the tribunal for the former Yugoslavia, the Nuremberg trials. But actually international law, especially in international business transactions, and even in some cases in our daily lives, international law is part of our law. And I'll explain that in today's lecture. So now another way of looking at, sources of law more traditionally is maybe just geographically looking at a map. You know what I mean? And I'm something of a map collector myself. So I apologize for blocking out Alaska here, but I wanted to make a few points in the bottom corner here. But if you look at a country like, let's say we're focusing again on our legal environment in Florida and United States, right? Like I said, we start with state and local law. And the important thing you need to know about state and local law, and this is all the more relevant today that we have we're still in a pandemic, is that the states have what judges call the police power, or police powers plural. Police power refers to the power to enact any type of legislation to protect the health, safety, or welfare of the citizens of your state and the residents of that state. Now, courts, when they are analyzing the constitutionality of, let's say, a mask mandate or any state legislation, they will very likely just say, look, does it have some rational relation? Does it have some logical connection to the problem it's designed to solve? And is that problem involving health, safety, or general welfare? If you answer yes to those questions, the law is perfectly legal. Now, there are some exceptions of the law might involve, fundamental rights and things like that, where a court might engage in a higher level of scrutiny. But we're not going to get into all that con law stuff right now. For now, I just want you to know that generally speaking, the states have very broad police powers. Now, states aren't required to exercise those powers. For example, here in Florida, Governor DeSantis has decided not to impose mandates, And so, but in other states like California and New York, the governors there have said, no, we're going to use our police power to impose vaccine and mask mandates. So the police power is very broad at the state and local level. Now, at the federal level, federal law, there, the main difference between state law and federal law is that the powers of Congress to enact legislation are technically limited to the powers given to it in the Constitution. And so there, what you want to know is Article 1, Section 8. You can look it up. I'm just going to focus on something called the Commerce Clause. The Commerce Clause gives Congress what courts like to call the commerce power. Congress can basically pass any law as long as it's rationally related, has a logical connection to any aspect of interstate or foreign commerce. And that's very broad. I want you to ask yourself for a moment, what activity doesn't have a connection to business and to commerce, right? Technically, there's a debate right now. President Biden gave this big speech a week ago saying that he's going to use some OSHA regulatory authority to impose a mask mandate on employers, or require actually a vaccine mandate on employers that have, like Disney and Microsoft, that have 100 employees or more. That's controversial. Does OSHA have that authority? But I can tell you, if Congress wants to enact a law right now, today, as we speak, saying that Congress finds, because we have a pandemic and the pandemic affects commerce, Congress will impose a vaccine requirement, not just on large employers or mid-sized employers, but on every single employer, on every single American, regardless of employment status. You know what I mean? They could do it under the commerce power. That's how broad the commerce power is. Now, what's interesting in this mask and vaccine mandate debate is that, Congress really hasn't stepped in. Instead, what you're seeing is a bunch of angry parents on both sides of the debate, arguing before school boards. I feel, to me, that's a gross dereliction of Congress's duty. I'm a big believer in federalism. Maybe this should all be decided at the local level. But when you have a pandemic, you have a problem of international, dimensions here, maybe the Congress should take the heat, take that vote and decide whether we're going to have a nationwide mandate or not, to have a common sense policy or not, But I'm just saying that Congress's powers are enumerated. And the most important of those enumerated powers is going to be the commerce power. And ironically, right, that's the power that gives, that's the power that allows Congress to regulate not only business, but the Supreme Court has said any activity, even if that activity occurs only in one state, but if the aggregate effects of that activity, that is to say, many people doing that activity at once or at different times, if it has spillover effects in different states or across the nation, then Congress can regulate it or pass a law. So that's why we have today the kind of situation we have where Congress is basically this very powerful, and they could pass almost any type of legislation. The last time we had a major debate about the scope of the commerce power was the Affordable Care Act, so-called Obamacare, because there what Congress did is say, we're going to require you to buy health insurance or pay a tax penalty. And so there it was controversial. It's one thing to regulate commerce, but does Congress actually have the power to make you engage in commerce by buying insurance? So there's no doubt states can do that, like with car insurance, because states have a general police power. But that was actually a legitimate debate. And in a 5-4 decision, the Supreme Court actually the Supreme Court, it was a complicated vote because Justice Roberts said no, that gave the 5th vote to say no, that would violate the Commerce Clause. But under the taxing power, Congress can go ahead and enact Obamacare. In my opinion, that's a poorly reasoned decision, but it was a political compromise, to not strike down the law. So that just gives you just a flavor of why federal law is so important today, and why federal jurisdiction, and we have federal law on almost anything, because almost anything is connected to commerce. Finally, we have international law, and we'll get back into the screen share here. And and you see maybe a little piece of Canada, a little piece of Mexico, but really international law refers to the law of nations. And so we'll talk about that at the end of today's class. Let's continue though. Let's look at each of these people. Who has the strongest case? Summers has a pretty strong case. Under what the Winklevoss twins in another different scene of the movie call Harvard law. And this is actually a really important point. I'm showing you here the homepage of the Harvard ad board. The point here I want to make to you is something scholars refer to as private ordering, or I call them private rules. Every organization, like UCF, but also every private employer like Disney, wherever like you want to work when you graduate college, every organization is going to have its own set of rules. Technically, right, that's not part of the legal system. That's not state law. That's not federal law. That's not international law. But it's important because, those are rules that are going to apply to you. And at the end of the day, when Zuckerberg had to face the music, and was probably given probation, was under Harvard law. He was ad boarded, right? So I want to throw that out. That should be part of your radar when we're thinking of the legal environment. That every organization has its own private law, if you will, its own private rules, through its own handbooks and mission statements and policies and contracts. And so that's actually, if you think about it, right, that's another aspect of the seamless web. I just want to throw that out there, an extra level of complexity. And this is why, a lot of like organizations like Harvard and, big companies, they'll have an in-house, a lawyer or a law firm that will help them, design these optimal policies and optimal rules to be consistent with, state and local requirements and federal law, and where applicable, international norms as well. So I just want to throw that out. I just want to throw that out there. That although I'm just going to mention that briefly, you know what I mean. I'm not going to really get into the law of Harvard in this class. It's fascinating. It's one of the oldest universities in our country, after William and Mary. But the College of William and Mary. That's also worth noting. All right, let's go back to our share here and our visual presentation. The next, by the way, who do I have here? I have a picture of the state attorney of the District of Middlesex County, where Harvard is located, MIT. They're actually, the Massachusetts actually has its own cybercrime law. And in fact, I've included in the module, if you want to take a look, I've included this law, in the module. I've included California cybercrime statute, and I've included also Florida cybercrime statute. And you'll see they're all different. One of the things I find really interesting about, because this crime, potential crime or alleged crime was committed in, Harvard, right, which is located in Massachusetts, right? So we're going to look at their local law, right, their state law. And I just want to tell you, if you look at this is why you always need a lawyer, because if Zuckerberg, if the government here the local government tries to bring criminal charges against Mark Zuckerberg, Zuckerberg's lawyer, I think a lawyer first year out of law school could get Zuckerberg off these charges dismissed, without even having to go to a jury, get the judge to dismiss the charges on a motion to dismiss. Because if you look at the statute and the way it's worded, and I apologize, this is you can see it's a pretty wordy statute, but if you actually, I've underlined the key phrases here. It says, whoever with an intent to defraud uses any commercial computer service, right? And then later, that term of art, commercial computer service, is defined. Again, lots of words to basically say something, electronic of value, monetary consideration, right? If you look at that statute carefully, and I'm going to level with you, Zuckerberg walks. He walks, because Facemash, where's the intent to defraud? Where's the commercial computer service that he's obtaining? I mean, yeah, he is hacking into the Harvard computer databases to obtain a bunch of student ID pictures. That's what he did, but if the statute is going to require an intent to defraud, and that the crime be committed for some kind of commercial, monetary consideration purposes, a judge is going to say, get out of here with this. You know what I mean? This is designed basically when somebody's trying to extort you on the internet. This is not designed for a student stealing pictures from his own university, that didn't even bother to adopt sufficient security measures to prevent him from doing this in the first place, So that's why you always need a lawyer. A lawyer could just get these charges. And by the way, probably this is one of the reasons why local charges weren't brought against Mr. Zuckerberg. But that still raises an interesting question. Why didn't any of his fellow students sue him? Think about, like, right now, who goes to Harvard, right? I think one of President Barack Obama's daughters goes to Harvard, right? And so 2003, Natalie Portman was at Harvard. It's like rich and powerful people, or I should say the children of rich and powerful people, go to Harvard, right? And so could Zuckerberg be sued civilly, for monetary damages? And it turned, oops, sorry, here, I pressed the wrong button. I want to get back into my screen share. Am I in a screen share right now? Yes, okay. So there is a tort, common law cause of action, where you, a private citizen, can sue somebody else another private citizen, or even a company for stealing your data or for invading your privacy. So here I have, this is, if Layla Bravo were to sue, or another fellow, Natalie Portman or whatever, another classmate whose picture was, used without her consent and posted on Facemash, they could arguably sue on invasion of privacy. Here, you don't need to memorize this. This is not a bar exam review course, but I want to let you know that invasion of privacy, actually there's 4 different ways that you as a plaintiff, you or John Morgan, right? You're a lawyer, right? Or Dan Newland. These are 4 different ways that you can prove that your privacy was invaded. The classic is intrusion upon seclusion. That's what we classically think of as invasion of privacy. But there are other forms, where somebody used your name and likeness without your consent, or somebody reveals private facts about you, not necessarily a picture, not necessarily, but information, data, and also this tort known as false light. When you present, you don't defame the person, you don't say anything false about, you don't say anything false, but out of context. Now, here's the thing, though, about invasion of privacy that I need to share with you. Again, if Zuckerberg has a lawyer first year out of law school, maybe you need a second year, maybe you need a lawyer here with a little bit more experience, maybe he could call me up and I could get him out a little bit out of this jam, But here's the thing about invasion of privacy, under the common law, in order to sue under invasion of privacy, you not only have to prove that, you were presented in a false light, or that private data, information was released, or that your image or likeness was used, or that, your actual privacy was invaded, the intrusion upon seclusion, as it's known legally speaking. You have to prove that in the first instance, you had and this is the phrase that courts use, you had a reasonable expectation of privacy. And here's the problem with Facemash, right? Zuckerberg stole student ID photos. And so the problem is, do you really have a reasonable expectation of privacy to your student ID photo, like on your Knights card, or even on your Florida driver's license, or whatever state you call home, and, you could argue that maybe, you should have a reasonable expectation of privacy. It's your photo. But if you think about it, these are student ID photos, probably Harvard owns them, you know what I mean? Not you. And even if that photograph belongs to you, do you have a reasonable expectation of privacy in a photograph that's meant to be, shared? Like when you go to the dining hall, you have to show your ID card, or you want to get into, an event at Harvard, you have to show your ID card, So that's a little bit of a closer question, That's an issue that I could see even going up to appeal had that case been brought. Now, the reality is nobody sued Mr. Zuckerberg for this, because it's 2003, you all. This guy's a sophomore. This guy's a nobody, right? Nobody knows he's going to become a billionaire in just about a year. You know what I mean? So it's like a year and a half, So yeah, if Zuckerberg's a billionaire and he does this to you, right, then that's a whole different story, right? Then yeah, I'm going to sue him because now it's worth my while, We'll see what Facebook does today, to basically defend itself against these type of lawsuits, But if you'll allow me, we'll talk about that when we talk about the common law. And in fact, invasion of privacy is a tort, so it's part of the common law. And I have reserved an entire lecture to the common law in the next class number 3. So let's hold off on that for now. I just want to introduce you that that's one of our sources of law, the local common law and tort law, et cetera, and actually a very important source of law, because that generates a large volume of the litigation that we see in our country. All right, let's now talk about federal law. And when we talk about federal law, I'm going to tell you right now, the feds have the strongest case against Mr. Zuckerberg. There's something called the Computer Fraud and Abuse Act. And please compare and contrast this to the Massachusetts statute, or if you go in Module 2, compare and contrast the CFAA with the Florida statute or the California cybercrime statute. And what you're going to see is that the feds, they have a really kind of an elegant definition of hacking here. It's accessing a computer intentionally without authorization or in excess of authorization. Now, later in the statute, because remember what I told you, Congress only has the power to regulate interstate commerce. So later in the statute, the CFAA, computers are defined, and I have the actual definition there as an interstate or foreign commerce or communications that's protected. So it's basically the way courts have interpreted the word computer in the statute is to say that if your computer is hooked up to the internet, it's interstate commerce automatically, So boom, even if the server is like maybe Jacksonville to Orlando, but it's part of a larger network that does cross state and international lines. So that's automatically a protected computer under the Computer Fraud and Abuse Act. And there's really, to me, very little doubt that Zuckerberg, had charges been brought, right, he could have been prosecuted under the Computer Fraud and Abuse Act, right? Because he used the computer in excess of, without authorization, or in this case, the Harvard computer database where the student photo ID photos were stored, right? He didn't have authorizations to take those photos, Or if he did have authorizations to access the photos of at least his residential house, he was in excess of authorization when he scraped those images and then posted them onto his illegal website, right? So here, there's a very, very strong case against Mr. Zuckerberg. Now the question becomes is, well, then why weren't criminal charges brought against Mr. Zuckerberg, right? That's a very legitimate question. And so let's go back to the screen share. And let me share with you something. And I accidentally put this slide out of order, but I'm going to talk about it right now. It's a concept known as prosecutorial discretion. And basically the prosecutor, whether it be the federal United States attorney, Carmen Ortiz, there in the District of Massachusetts back in 2003, or the local DA, Marion T. Ryan of Middlesex County, right? The prosecutor decides when and if to bring criminal charges, right? They have discretion basically not to prosecute you. One way of thinking about this is, and you can see the factors that are relevant in making a decision of whether to bring a case. One way of understanding prosecutorial discretion is by, think of like speed limits, for example. Think of like speed limits, right? In the lingo, there's something called tolerance, where even if you're 5 miles per hour over the speed limit, generally speaking, unless there are children present or whatever, 2-lane road or something, generally speaking, you're not going to be pulled over for that. Now, if you're 20 miles over the speed limit, even there, you're probably not going to be pulled over, right? But your probability of getting pulled over is going to increase dramatically if a marked or unmarked police vehicle happens to be nearby, right? So it's like, that's what we mean. There's discretion in how you enforce the law. Now, that could lead to a lot of inequities, right? One could argue, well, maybe the real reason why Zuckerberg didn't get prosecuted is because he's rich and white, and that's the Black Lives Matter critique of the legal system, but the way I look at it a little bit more pragmatically is in that, Zuckerberg at that time's a nobody, right? And you could say what you will about him, that he's a jerk for doing this, but the movie, there's one inaccuracy in the movie, and that movie is, and that inaccuracy, I should say, is unflattering to Mark Zuckerberg. The inaccuracy is that the system never did crash Harvard's, overall computers. But because there was so much traffic on that site, because the people who were on it basically stayed on it for a number of hours, and as more and more students got on, and remember, we're not talking about broadband internet here or Wi-Fi, we're talking about dial-up. We're talking about dial-up here. We're talking about the old days. And the thing about it is the computer, the system started really slowing down, kind of like what's happening at UCF right now, right? There's a big slowdown, and so it's one of the reasons why I'm recording the lecture. So it's like when Zuckerberg saw that, he realized, I could be in big trouble. And in fact, what's not in the Harvard Crimson article, what's not in the movie, is that already a lot of students had been ad-boarded precisely for that, for doing internet activities that ended up, just doing damage to the Harvard computer network. Now, nobody had been ad-boarded for hacking. Zuckerberg would be the first. And this was so Zuckerberg, to his credit, he took down the website. Once he saw that the system was about to crash, he took it down. And again, to his credit, he gave one of what would turn out to be, a cycle of apologies, right? He apologized to the ABHW, right? He apologized to Forza Latina, right? Now, whether those apologies, by the way, is in the Harvard Crimson article. That's why that article is so worth reading. It's better than the movie. Whether those apologies were sincere or whether they were BS apologies, which is what I suspect, to minimize the ad board penalties, right? He did apologize, right? So the prosecutor, Marion T. Ryan, she's a busy lady. Massachusetts law is not really designed to deal with this. The feds could come in, they have the resources, they have an elegant Computer Fraud and Abuse Act. But again, they're not going to bring charges against a sophomore. Ironically, though, I will tell you, a few years after the Facemash incident, Carmen Ortiz herself, she brought Computer Fraud and Abuse Act charges against one Aaron Swartz, a graduate student at Harvard, actually. What did he do? He downloaded illegally a bunch of scientific research articles at MIT. And what's interesting is, that Aaron Swartz, really he's actually one of my heroes. He actually, his whole thing was that the National Science Foundation and the NIH, National Institutes of Health, they actually fund most, if not all, of this scientific research that's going on, at MIT and at Harvard, all these places, right? And then these professors are publishing, these scholars are publishing these papers in scientific journals, about their research. So why can't the public see the results of that research for free? If you're not a university professor or a college student, those articles are gated or paywalled, and sometimes they go for as much as $80-$90, or more, just to access a scientific article. And so the taxpayers paid for this stuff, so he was what he called a white hat hacker or a hacktivist. Carmen Ortiz didn't see it that way, so she brought criminal charges. The whole sad thing about this is actually tragic, is that Swartz committed suicide while he was awaiting trial. And so, the case was ultimately dismissed, but we lost. He was a young man. He was like, I think, really a leading statesman of his generation for internet freedom. And so to me, it's a real tragic, to me, it was an abuse of federal power, I would say, in bringing charges against him and not against Zuckerberg, but the difference was that Zuckerberg was doing this stuff for free. There was no real monetary effect here, and he took it down right away. Swartz was affecting the business model of a lot of companies that actually, the ones that sell sell access to the research articles. There's one company called JSTOR, for example. There's others, big publishers like Routledge and others, in Europe. And so that started to affect people's profits, and that just became a whole different, kettle of fish. So I just wanted to throw that out there as to the importance of prosecutorial discretion. All right, let's continue that law. And let's see here. Let me get back into the screen share. And then I can jump in already. All right, I think we're in the screen share right now. And what I want to share with you is something called the Budapest Convention on Cybercrime. And the Budapest Convention on Cybercrime, there's actually an international treaty that deals with hacking and other forms of criminal activities engaged in on the internet. Now, the main thing that this treaty does, it just makes it easy to extradite, preserve evidence, and extradite cyber criminals, among the the signatory states. Unfortunately, the Russian Federation and the People's Republic of China, Brazil, these are a few of the countries that have not joined the Budapest Convention. So if you are going to be engaged in cybercrime, those are probably some of the places you want to hang out in. United States, however, in 2008, if I'm not mistaken, joined the Senate, ratified the convention. And so this is now part of our United States domestic law, once it's ratified by the Senate. And you can see that this statute, so kind of, I'm not gonna, you don't have to get into all the details, just know that it's out there. I think the larger point that I want to make here is that what's really interesting about international law is that, notice, even though the Budapest Convention was negotiated and, it took effect in 2001 in Europe, because of the members of the European Unions were the ones who negotiated the treaty, it was not part of our law until 2008. So this is an interesting aspect of international law, right? In our case, the Constitution of the country will describe the procedures for adopting international law as part of our local, as part of our domestic law. And so treaties, in this sense, right, has this kind of optionality to it, right? That there could be an international convention out there like human rights or, convention for, protection of wildlife or whatever. But until the US Senate, right, until the United States ratifies the treaty, then it's not part of our law, right? So that's sort of the key. That's sort of the key thing there. That it's at some point in time, the Senate has to come in and make an affirmative declaration that we're going to ratify the treaty and incorporate it into our legal system. That's an oversimplification. The Congress still has to enact also enabling legislation, and whether to recognize private causes of action, for example, under the law, those kind of and other issues, jurisdictional issues, where the suits will be brought and that kind of stuff. But the point about international law is that has that sort of like, you have to opt into it before it becomes part of our domestic law. Now, that said, another aspect of international law are so-called international customs and international norms, right? And that technically, that's part of the international common law that courts often will look to, if there's a gap in the international, if there's no treaty, or the country hasn't joined a treaty, but there's an international issue. And that's usually just decided on a case-by-case basis. But a big part, or not a big part, but a significant part of the Supreme Court's caseload is issues involving some aspects of international law. So I mentioned that that's technically also part of our legal system. Now, the last image I want to leave you with is, and before I do that, let me just go ahead and pull this up here, is it's the images on the homepage of the course. It's the address of the Facebook's headquarters on the East Campus before they built the newer West Campus, called One Hacker Way. And I put this on the homepage of the course as well, because it kind of highlights one of the things about hacking is that generally, when you see, when people are talking about hacking in the news, right, is generally a very negative connotation, right? It's basically the implication being something illegal is going on, or at the very least, something immoral. Or could it be a harmless prank? Or could it be something like Aaron Swartz, some kind of, a moral affirmation, of what's right and wrong? And what's really interesting is that in computer science circles and, software developer circles, those kind of things, computer geeks and stuff like that, to call yourself a hacker is actually considered a great honor, and sometimes you may have heard like a life hack, to make your life a little bit better or easier, that's what hackers think, but they try to do that on the internet. Now, what's happened over the years is hackers have developed sort of a code, and on one end are the bad guys that are referred to as black hat hackers, like in the Westerns, whoever's wearing the black hat, that's the bad guy, right? So in The Searchers, John Wayne is wearing the black hat. He's the bad guy in that movie. It's a really remarkable movie. But then hackers like to also, but that doesn't mean all hackers are wearing black hats. There's also white hat hackers, right? And those are the good guys always in the Cowboys movie. Those guys that rescue, the damsel on the train tracks or whatever it is, find the gold and give it back, to its rightful owners. So the white hat hackers are people who do things for, ethical purposes. And Aaron Swartz, for example, is a great example, I would say, of a white hat hacker who saw a great injustice. And by the way, although he died, I don't think he died in vain, because now the National Science Foundation and NIH, as a condition of receiving grant money, researchers have to, after 6 months within publication, they have to make their research available to the public for free. So now it's a condition. So Swartz, ended up in a small way changing stuff for the better. Now, that said, though, I want to make one last point. Notice, however, that none of the laws that you saw that I showed you today, like the International Convention on Cybercrime, the Budapest Convention, right? The Federal Computer Fraud and Abuse Act, or even the local laws that I put in our module, the California, Florida, and Massachusetts state cybercrime law, none of them make those distinctions. None of them say, oh, you get a pass if you're a white hat hacker. No, you go to jail or pay a fine if you use a computer without authorization or do whatever is prohibited in those other statutes, right? And so there's no distinction between white hat and black hat hacking. And that's really one of the things that the Aaron Swartz case brought to bear. Now, because of this, right, we have to talk about one last thing called morality. Oftentimes in the legal context, we call this the natural law tradition. Now, because natural law is not really technically one of the main, to me it is, but it's in the canonical sense, classroom setting, it's not written down anywhere, right? So you can't really point to it. Yeah, it's just sort of out there, So I'm going to record a separate lecture in the next day or two, and I'll post it to YouTube. I won't be asking about this on the quiz, but I want you to have a well-rounded picture. Natural law tradition, really, in our country, the most famous statement of natural law is going to be the Declaration of Independence, of 1776. The idea that all men and now women have inalienable rights endowed by their creator, and that among these rights are life, liberty, and the pursuit of happiness, So that's an example of what I mean by natural rights, that the reason why we have law is so that people can pursue moral purposes. The moment you start doing immoral things or you use the law in an immoral purpose, that doesn't mean it should still, we should still question that, and that's, if you think about the Nuremberg trials are a good example of that. All those Nazi officials who were hanged, right? They were obeying Hitler's laws, you know what I mean? That were duly ratified by the Reichstag, the German parliament. But in reality, right, they were committing the most heinous and vicious of war crimes in world history, right? And they were rightfully put to justice for what they did, And more recently in our country, Dr. King, when he was in the Birmingham jail. Now, King broke up a lot of laws to protest segregation, but it was when he was in Birmingham jail in April 1963 that he wrote the famous letter from a Birmingham jail, and he cites the natural law tradition to justify why he's willing to break the law, for his moral crusade, to do justice for his people and for to redeem the value, what America really stands for. So natural law to me is, I would consider the most important of all the laws, But it's, like I said, it's not written down. So I'll talk about that in a separate lecture, and that's more just for your well-rounded education. All right, with that, then I'm going to go ahead and stop the recording.